Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Lyles Parker. Thank you for joining us for this new webinar series with the Home Care Association of Louisiana. Today's webinar is entitled, Are You Personally at Risk? Update on the DOJ's Push for Individual Accountability. Our presenters today are Robert Saltformaggio and Richard Pecore. Robert is a senior counsel at Lyles Parker. He focuses on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Robert represents clients nationwide. He has experience in assessing client records for documentation, compliance in private payer and CMS audit preparation, as well as identifying and improving documentation deficiencies. As for Richard Pecore is a 30-year attorney at senior counsel with Lyles Parker. His office is in Houston, Texas, who has been with the firm for about 12 years. He focuses mainly on administrative appeals, regulatory healthcare compliance matters, billing contracts, and compliance programs for our clients. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the question tab or box, and we will address as many as possible at the end of the presentation. So without further ado, I present your speakers, Robert Saltformaggio and Richard Pecore.
Thank you, Gio. This is Richard Pecore. I wanted to say one thing before Robert's going to launch us into this, because there's a lot of information today, and it's going to kind of come at you hard and fast. So we've got a lot of things to cover. I want to give you kind of an overall 30,000-foot view. The government is trying to get to personal liability, but in order to do that, they have to pierce the corporate veil. Now, the way you prevent that is to, abide by the law. What does that mean? It means watch your relationships. Who are you working with? Business relationships, partners, NCOs, contractors, agents, especially marketers, anything to do with referrals. That's going to include your medical directorships. Your compensation, kickbacks are related to compensation. You got to watch that. And watching your claims. You're talking about services actually being rendered, billed accurately, patient ID and identity theft, and even money laundering. So the government has 16 ways to Sunday to catch wrongdoers. This is what we're going to be going through today. It's a bit of a minefield. We're going to try to give you a map. So Robert, take it away, please, sir.
All right, thank you, Richard. I appreciate the overview there. So for everyone online listening, we're going to just kick it off with a little overview of the last 25 years or so of the federal enforcement. And to begin, we're going to start with the Enron scandal. Back in 2001, after the fallout from Enron, we saw the second Bush administration really target a lot of the top-level CEOs and executives. So 24 just at Enron itself, and then overall with the entire accounting scandal, we saw more than 750 individuals prosecuted in connection with that scandal. Now, as the Bush administration's time went on, we also saw another crisis rise with the financial crisis and the global fallout there. Worldwide, we saw countries kind of pursue a similar tactic in really targeting high-level officials and CEOs throughout the financial industry. Ironically, though, here in the U.S., we saw that only one individual was prosecuted related to the financial fallout, and he was only sentenced to 30 months for inflating the price of subprime mortgages. So even within one administration, we see a real change really going initially after those high-level officials to not doing so. Now, when President Obama's administration came in, they decided to take a change even further, and they kind of told the companies that, if you're willing to provide information and evidence to identify the relevant actors, we're going to consider that as part of our broader analysis and whether we're determining if a company is cooperating with the government's investigation. And so even if you're not identifying the individuals specifically, the government was saying, hey, can you just give us a little bit of information? And we're going to consider that as a factor in whether or not you're helping us out. Next slide. Now, as the Obama administration's time wore on, we start to see that they're really going to start clamping down on individuals. And back in 2015, the Obama administration's DOJ published kind of this guidance that outlined 6 steps that would ensure corporate investigations were handled correctly. And broadly, these 6 steps included, to get any cooperation credit, the corporations must provide DOJ with all the relevant facts about individuals who were involved in misconduct. They also recommended that the investigations, both criminal and civil, should focus on those individuals and not just the companies themselves. Attorneys, both the criminal and civil, need to be in routine communication with each other. So make sure, the left hand is talking to the right. Companies should ensure that they don't have any corporate resolutions that provide protections, either criminally or civilly, for any individuals, whether from the highest ranking, executive to the lowest ranking employee. Cases should not be resolved without a clear plan to resolve any related individual cases. And then finally, civil attorneys should evaluate whether to bring suits against individuals based on the considerations that go beyond an individual's ability to pay. So again, those were the 6 steps that DOJ kind of outlined to ensure that all the corporate investigations were being consistently handled. Next slide. Now, once the Obama administration left, we have, again, another change in administrations. And now we have, with the Trump administration, another policy change. So here, President Trump directed his DOJ that no longer did the corporations have to disclose information about all the employees who had been involved in the wrongdoing, which was the standard under the Obama administration. Now, you only really had to identify those who were substantially involved in or responsible for the criminal conduct in order to get that cooperation credit. So again, we see a new administration comes in and a big change going from, the Obama administration wanting any individuals to have the Trump administration saying, hey, we just want those who were substantially involved. Next slide. Okay, well, the Trump administration lasted only 4 years, so we have President Biden's team come in, and what do you know? We have another change in policy. So here, under President Biden, his Attorney General, Merrick Garland, kind of directed and made clear that they're going to focus on any individuals who commit crimes or profit from the corporate malfeasance. And really, that again, it was no longer just going to be those who were substantially involved. They were going to look to any individuals who were involved in the misconduct, again, regardless of their position, status, or seniority. So here we see the Biden administration kind of revert back to the guidance that was under his previous boss, President Obama. So, it's really difficult for everyone to kind of follow these guidelines when they're going from one thing to a substantial change and then back to the original. Next slide. So now the Biden administration kind of released some updated guidance back in September 2022. And, this new guidance had that prosecutors needed to consider other, things when they're making a decision on whether or not to prosecute companies and individuals. And when really assessing those corporate compliance programs, prosecutors should consider the company's compensation agreements or arrangements, or what the DOJ termed these compensation systems that incorporated, various terms and guidelines such as clawback provisions that could try and shield current or former employees from, any criminal misconduct. So essentially, kind of what this boiled down to is that, the government is really telling companies that, hey, in those company policies and employee guidelines that you have everyone sign, you really can't have any terms or provisions in those policies that are going to try and shield any company or employee misconduct that can involve, subsequent civil or criminal misconduct. Next slide. Well, and finally, we had another update back in October of 2023, and this was what the DOJ termed the safe harbor policy for voluntary disclosures. And essentially what this said is that for any company that's an acquiring company, so let's say you have a home health agency and you're buying out your competitor. You're going through all of your due diligence in the purchase agreements, and you come upon some misconduct, whether civil or criminal, that you saw in the seller. Well, the DOJ is going to say, hey, if you notify us in a timely and appropriate manner of this misconduct that you found, during that purchase, you're going to kind of receive some credit that the DOJ will come after you. So what this kind of tells you is that, anytime you're involved in, purchasing, another company or a competitor, it really behooves you to do your due diligence and comb through all of the sellers, purchase agreements, employee, contracts, to make sure that, you're acquiring a company that does not have any underlying misconduct, fraud, whatever. But if you do, you need to tell the government in a timely and judicious manner in order to kind of receive that credit. Next slide. Do we have any questions kind of, given that broad overview before we move forward? Okay.
I'm seeing that there's no questions.
Okay. So, healthcare fraud is kind of our focus here. And the healthcare fraud is just kind of one focus of the DOJ's broader fraud section. That section also focuses on financial crimes and other, market integrity and major fraud, issues. But really, healthcare fraud is the bread and butter. It's the primary focus of the DOJ's fraud section. Next slide. And kind of just in the last, 30 or some odd years, there's really kind of been a consistent nature on those who are prosecuted for, these kind of fraud crimes. One is that these companies are primarily domestic, private, and small, meaning that they have less than 50 employees, which, if you consider the broader U.S., that's most businesses. Small businesses comprise most of the businesses in the U.S. And again, those are going to be the businesses that are most likely to be prosecuted and sentenced for misconduct. An overwhelming majority of these businesses do not have a compliance or ethics program. And even those that are prosecuted, very few have an effective compliance or ethics program that could help give them, a sentencing reduction going forward. So, what does this tell us? One is that you need to have an effective compliance and ethics program in place to ensure that you're, meeting all the statutory guidelines and requirements that we're going to touch on later. Because otherwise, you're just going to be the focus of the government coming after you. Next slide. So really quickly, I just wanted to kind of give some recent examples of companies and individuals that have come, under the DOJ's hand just in the last year or so, just because I felt like these cases were kind of typical of what we see out there. So, here we have a home healthcare agency out in Arizona who recently agreed to pay $10 million to resolve allegations that it violated the False Claims Act. So what did it do? Well, according to the government, it was falsely billing, federal healthcare program for employees who were not physically present in the patient homes. This agency was paying kickbacks in the form of patient referrals via what it called its Friends and Family program. And it was also making in-kind payments to cover food, internet, travel, and other expenses to patients and their families to get them to sign up for home health. And notable with this case is that it arose from allegations from a whistleblower within the company. So, an employee filed what we call a key tam suit or a whistleblower suit with the government, kind of disclosing all of these misconduct allegations. And so that's how this case arose. Next slide. Also, in last month, I guess not last month, in January of this year, in Michigan, we had an individual who was sentenced to 9 years in prison after he orchestrated nearly $10.8 million in healthcare fraud. So the allegations against this individual is that even though he was excluded from Medicare, he used straw owners to kind of conceal his identity in order to, obtain ownership of his home health company. And then over a 2-month period, he and his co-conspirators were paid nearly $2.8 million for billing services that were not rendered. And then after they recouped all of this money, they used bank accounts, with shell corporations and overseas accounts to try and hide everything. Next slide. Also in Michigan, last year, we see another case where the government was charged in 23 residents involving defrauding the federal Medicare program worth more than $61.5 million in illegal kickbacks and bribes. So according to the government, once again, these individuals, similar to the case in Michigan this year, were using straw owners, including family members and friends, to hide their ownership interest in order to fraudulently bill Medicare. And according to the government specifically, what they were doing is that they were paying bribes to their co-conspirators in order to recruit patients to sign up for home health, even though many of these patients didn't even meet any of the home health requirements, being homebound or requiring, skilled services. These individuals also entered into some quid pro quo relationships with the physicians in order to get information to file those fraudulent claims. And then similar to the last individual, they were misappropriating all these funds and using shell companies and overseas accounts to hide their legal recoupments. And then another individual who was kind of also involved with this case was ordering the physicians he employed to again certify patients for home health care when they didn't meet the certification requirements. Next slide. Just a couple cases down in Florida. Again, it's just involving individuals who, in the first case in January, recruiting folks from overseas in Cuba to sign up for Medicare enrollment and appearing as the owners of healthcare agencies, home health, to hide their identities, and then, submitting false claims using errant and illegal, false patient identification and, rendering services that weren't, provided, or I should say billing for services that weren't provided. And then again, using all these proceeds to turn into cash and make, personal purchases. And then kind of one thing Richard talked about early in his intro about, really reviewing your medical director agreements. Well, in this last case in Florida, that's what happened, is that these individuals were alleged to pay illegal kickbacks to physicians as outlined in a sham medical director agreement. So, again, these were just kind of some recent cases we saw that were kind of notable and very consistent in kind of the fraud that we see involving home health agencies. Next slide. So now we're just going to kind of give a legal overview. We're going to start with the False Claims Act and then move into the anti-kickback statute. So first, the Civil False Claims Act said that, it's illegal for anyone who knowingly, and I really want to stress knowingly, submits or causes to be submitted a false claim to the government for payment. So, this term knowingly is what we want to stress here. And it doesn't actually mean you have to have actual knowledge of, submitting the false claim. it can include a reckless disregard or deliberate ignorance. So you can't just be a camel, hiding your head in the sand and pretending like you don't see anything, illegal going on. If you're deliberately ignorant of any false claims being submitted for payment, you're going to be liable under the False Claims Act. And generally, there's a 6-year statute of limitations with the FCA, although that can be extended up to 10 years, depending on when the government knew or should have known about that violation. And with damages and penalties under the FCA, you could be liable for civil penalties and what's called treble damages, or 3 times the damages. So, let's say you have, you're liable for $100,000 in damages. Well, that can be extended, triple that up to $300,000 in damages. So, there's really a lot of, liability when you violate the FCA. Next slide. So another approach another statute that the government uses to go after and attack fraud is what's called the anti-kickback statute. Kind of just brief background here, just kind of want to talk about the evolution of what we call the scienter, or kind of the knowledge and intent requirements under the kickback statute. When it was originally made law, it just said that whoever furnished items for which they were paid and received an illegal kickback or rebate would be guilty. Now that was very broad and kind of encompassed a lot of individuals who may not have had any intent or knowledge requirements of submitting these false claims. So in 1980, Congress introduced a new proof requirement of you have to have knowing and willful knowledge. So now it says, now the statute reads that whoever knowingly and willfully furnishes these items is going to be liable. So now again, we have that scienter requirement. Next slide. So, even though they had added that scienter requirement in 1980, we saw another change when the Affordable Care Act was implemented back in the early 2010s. So now that an individual doesn't need to have actual knowledge or specific intent to commit a violation. So here, the government, there's less of a burden for the government to show that you violated the AKS. So, when it was originally published, it was way too broad. And then now they kind of narrowed it back in the 80s, but then now they kind of broadened it back just a little bit so that you don't have to have actual knowledge or specific intent. Next slide. And kind of just briefly want to just touch on the penalties here. They're different than the FCA. So here, you can be sentenced up to 10 years in prison, fines of up to $100,000. You can be excluded from participating in both federal and state healthcare programs, and there are penalties up to $50,000 per violation. So a little bit different here than the FCA. Next slide. Okay, I think with that, I'm going to turn it over to my colleague Richard to kind of start diving into some of the safe harbors that the government has drafted that can help you avert any liability under the AKS.
Thank you very much, Robert. You did a great job on that. I hope folks took the FCA and anti-kickback statutes to heart. The government has a lot of ways to come at you. Your job as home and health owners, employees, participants is to avoid those. And we're going to talk about a few more of the laws that are involved with this. The safe harbors are part of the Stark considerations, which are the self-referral laws. Basically, anything has to do with referrals, it's something you got to be really careful with, because that's a lot of gotcha law. There are safe harbors, though. As the anti-kickback statute shows you, the scope of coverage is large and very broad. In 1987, Congress authorized the Health and Human Services, OIG, to issue safe harbors, and they're voluntary, they're not mandatory. They're not necessarily a violation of the anti-kickback statute if one or more elements haven't been met, but it's up to you to prove that the safe harbor exists, and it's not an absolute defense. It's an affirmative defense in most cases, which means the burden's on you to show that it exists. The number of safe harbors in the federal anti-kickback statute changes all the time. Currently, there's 11 statutory and 36 regulatory safe harbors. Next slide, please. Most likely that are common to arise in the physician business arrangement would be personal services and management contracts, employment safe harbors, and small entity investment safe harbors. We're going to talk about the first two. Next slide. The Stark laws and the safe harbors are all very complex. This is going to be just an overview of it, but if you find yourself in that situation, seek out legal counsel. For personal services and management contracts, which is governed by 42 CFR 1001.952D, in December 2021, there were some changes made to the personal services and management contracts and outcome-based payment regs. And before the issuance of the final rule, to qualify for it, they judged it by the aggregate compensation, which had to be set in advance. This made it really, really hard for indeterminate hourly compensation or per diem businesses to figure out what that was going to be. So when they changed it, they made it easier so these folks could be included. So now you only have to set the methodology and define and identify what that compensation tool is going to be. And there's other restrictions, but that's the main gist of it. Specifically, remuneration, which means basically anything of value, does not include payments made by a principal to an agent as compensation for the services as long as the following standards are met. So the agreement has to be in writing, it has to cover all the services the agent provides, and it has to specify the services the agent is going to provide. The term of the agreement can't be less than a year because statute of frauds means it has to be in writing. And the methodology that we just talked about that has to be identified has to be set in advance, consistent with fair market value in dealing with arm's length transactions, and is not determined in a manner that takes into account the value or volume of any referrals. Remember what we said before about referrals, or business otherwise generated between the parties for which payment is made by Medicare, Medicaid, or other federal health care programs. What they're talking about here is the kickbacks and the volume and the money, all this, whether it's tied to any referrals, that's when the whole self-referral law comes in play and it all becomes very iffy. You have to be very careful when you're dealing with the referrals. The services performed in the agreement, they can't violate state or federal law, and it has to be for a commercially reasonable business purpose. Next slide, please. As far as employment safe harbor, a bona fide employee safe harbor to the AKS is one where there is no violation of the statute for payment by an employer to an employee who has a bona fide employee relationship. Of course, that's been subject to possible changes lately as far as what that definition means. The IRS definition governed for a while. It's kind of a moving target. But this is another affirmative defense for which you have the burden of proof of showing that it exists. The Fifth Circuit found that a safe harbor provision adopts the definition of an employee in 26 U.S.C. 3121 D2. And they basically reiterated the Supreme Court, and they stated that the key factors include the 13 things you see below you: the hiring party's right to control the manner and means by which a product is made, the skill required, the source, the instrumentalities and tools, who owns the tool work, location of the work, duration of the relationship between the parties, whether the hiring party has a right to assign additional projects to the hired party, the extent to which the hired party has discretion over when and how long they work. Do they control their own hours, or does the hiring party? Method of payment. Is it commission? Is it a straight salary? Is it a flat fee? The hired party's role in hiring and paying assistants, whether the work is part of a regular business, whether the hiring party is in business, the provisions of employee benefits, if any, and the tax treatment of the hired party. Next slide, please. So let's talk a little bit about medical directorships. What does OIG say about fair market value? In June 2015, OIG issued a fraud alert called Physician Compensation Arrangements May Result in Significant Liability. As a clear warning to both physicians and organizations who employ them, they noted OIG recently reached settlements with 12 individual physicians who entered into questionable medical directorship and office staff arrangements. They allege that the compensation paid to these doctors under the medical directorship arrangements were improper remuneration under the AKS for a number of reasons, including that the payments took into account the physician's volume or value of referrals and did not reflect fair market value for the services to be performed. The physicians did not actually provide services called for under the agreements. So it was a scam. It was all about paying for referrals, and they didn't really do anything else. OIG also alleged that some of the 12 physicians had entered into arrangements by which another one of their affiliated or owned businesses paid the salaries of the physicians' front office staff. So they were avoiding those costs in their overhead and misrepresenting their numbers that way and committing fraud from those sources. Because of this arrangement, they relieved the physicians of the financial burden that would have otherwise occurred. They alleged that the salaries paid constituted improper remuneration to the physicians, and the physicians were an integral part of a scheme and subject to liability under the civil monetary penalties law. Next slide, please. So the moral of the story is it's got to be a legitimate arrangement. They've got to provide medical services. You can't just hire them to get the referrals and expect everything's going to go well. The thing that always astounds me is that folks do not have a concept of the federal government's breadth and scope and resources. The amount of money they have really, for all practical purposes, is limitless, especially when compared to yours. They will find you. People that are committing fraud do get caught. There's just too much of a paper trail. Examples of problematic conduct, more of them, recent kickback risk areas. Just be careful of your business arrangements. As we mentioned before, an individual entity that can refer business to your practice or a home health company. You don't want to get in a kickback situation with them. Just be really careful. If you're not doing background checks on every single person, company, business that you enter into an arrangement with before you sign the contract, you're not doing your due diligence, and you could step right into a trap. A continuing concern of the government involves lease arrangements, potential referral sources for that, medical directorships, as we mentioned before, that's a common area problem. The dine and dash approach for lunch and other goodies, boy, got a horror story on that one. We had someone that had literally hundreds of these, and they kept a logbook, for heaven's sake. And they even had the reps sign them, and they would be bringing in $100 or these $200 and $300 gift baskets, birthday presents, Christmas presents for the staff and for the doctors. And this was a gold mine. This was an evidence log for the government sitting right there that they committed and admitted to all by themselves. Oh my gosh. Anything of value could be construed as a kickback. As a practical matter, pretty much anything that's $20, $25 is going to, more than that, it could attract attention. So little minor stuff. I'm not going to say it's okay. I'm not saying it would be likely to go unnoticed, but basically anything of value can be construed as a kickback when you talk about the government. So be careful. Sham arrangements for speaking fees, loans, research grants, anything like that for which you receive referrals. Again, financial interest in a home health company or a lab or anything like that that you're getting referrals from. That's another potential start problem as far as kickbacks for referrals. Giving cash gifts, anything of other items. We talked about that. Any type of remuneration, which is something of value, like a gift card, sports tickets, liquor. Like I said, it can be anything. So, it's just something you got to be careful with. It used to be common practice. It's starting, especially with the artificial intelligence sort of claims analysis and sort of things that they're doing now. It's easier to get attention attracted to your entity. And if you attract attention for that, it's easier for them to spot something like, improper gifts and things like that once they're in there. So just be careful. Next slide, please. Okay. False Claims Act liability. Federal Anti-Kickback Statute and False Claims Act used to be viewed as separate and distinct tools. And the False Claims Act were generally used in civil matters. AKS were generally used in criminal matters, but that's changed over the last 20 years. Starting around the 1990s, whistleblowers started asserting violations of Civil False Claims Act in cases that would typically be pursued as a criminal AKS violation. And remember, all these also tie in with civil monetary penalties law. So these cases often involved fact patterns where parties were alleged to have violated the AKS and in the process billed for services that were allegedly worthless or made false express or implied certification to the health, Medicare or Medicaid programs. And with the 2010 passage of the Affordable Care Act, the government no longer needs to bootstrap such a case. Under the HCLA, a claim submitted in violation of the federal anti-kickback statute is automatically considered a false claim for purposes of the FCA. Next slide, please. So common statutes cited in criminal healthcare cases include the Healthcare Fraud Act, 18 U.S.C. 1347. It's unlawful for any person to knowingly and willfully execute or attempt to execute a scheme or artifice to, 1, defraud any healthcare program, or 2, obtain by false pretenses any money or property owned or under control of a healthcare benefit program. 2 important points is 18 U.S.C. 1347 covers government and private payers, which is something new. And as far as the AKS, the government does not have to show, again, that the defendant had actual knowledge or specific intent. It's a strict liability statute. Obstruction of a federal audit, that's 18 U.S.C. 1516. Whoever with intent to deceive or defraud the United States endeavors to influence, obstruct, or impede a federal auditor in the performance of official duties relating to a person receiving in excess of $100,000 directly or indirectly from the United States in any one-year period under a contract or subcontract. In other words, if you interfere with a federal investigation. The term federal auditor means any person employed in a full or part-time or contractual basis to perform an audit or a quality assurance inspection on behalf of the United States. So if you get a contractor from HHS, yeah, that qualifies. That's a federal auditor. Next slide, please. More common statutes, aggravated identity theft. That's 18 U.S.C. 1028A. More and more prosecutors are including a charge of aggravated identity theft in healthcare fraud cases. Under this statute, whoever during and in relation to a felony enumerated in Section C, which is a predicate offense, knowingly transfers, possesses, or uses without lawful authority a means of identification of another person shall, in addition to the punishment provided as such, the predicate offense, be sentenced to a term of imprisonment of 2 years. So that's just 2 years of prison tacked on to anything else that the other statutes add. So examples of the 60 different predicate offenses include relating to false statements or entries generally, relating to false statements related to healthcare matters. 1347 is healthcare fraud, 1343 wire fraud, 1341 mail fraud. So like I said, there's 60 of them, so take your pick. But in Dubin versus United States, which was a 2023 case last summer, or about 18 months ago, 1028A is violated when the defendant's misuse of another person's means of ID is at the crux of whatever the underlying criminal offense is, rather than merely an ancillary feature of a billing method. So being at the crux of the criminality requires that more than a causal relationship, such as facilitation of the offense or being a but-for cause of its success. So it raised the connection standard a little bit. Next slide. False claims under the criminal false claims statute, whoever makes or presents to any person or officer in the civil, military, or naval service of the United States or to any department or agency thereof, any claim upon or against the United States or any department or agency thereof, knowing such claim be false, fictitious, or fraudulent, shall be imprisoned for not more than 5 years. So now we're up to 7. We've got 2 years from before. We got 5 years now. You're starting to see the pattern here. Each one of these includes additional penalties, and that can include prison time when you're talking on the criminal side. False statements involving healthcare programs, 18 U.S.C. 1035, unlawful for any person in any matter involving a healthcare benefit program, and in connection with delivery or payment of healthcare services, knowingly, 1, falsify or conceal a material fact, make a material representation, or 3, use a document knowing it contains a material representation. That can add 5 years. Statements or entries generally, section 1001. There's no specific section for a false statement prosecution, but they'll use 1001 to prosecute the defendant. This is kind of a catch-all provision. It's unlawful for a person knowingly and willfully, number 1, falsify, conceal, or cover up any trick, scheme, or device of material fact. 2, make any materially false, fictitious, or fraudulent statement or representation. Or 3, make or use any false writing or document, knowing the same to contain any materially false, fictitious, or fraudulent statement or entry. Are you starting to see the pattern here? They've got, like I said, 16 ways to Sunday to pick up people who violate the law, commit fraud, commit waste, fraud, and abuse, or commit criminal acts of fraud. They've had decades and decades to put these statutes together, and they keep adding to it. So these people do get caught. Next slide, please. So what are some non-kickback problems identified in recent cases? Other kinds of problems you should be aware of and try to avoid. Failure to properly document support of medical necessity. Boy, oh boy. This is one of my pet peeves. That and cloning of notes. If it doesn't have unique information, the note is cloned and they'll kick it out. You get too many of those and you've got a pattern of fraud. So you can't over-document medical necessity. Certification documentation, research, progress notes, plans of care, they got to comply with the documentation requirements under the State Medical Practice Act and any requirements set out in applicable NCDs or local coverage determinations, the Medicaid rules, Medicare. When's the last time you reviewed these requirements to qualify for coverage and payment of the services you are billing? Just check what you're doing. This is why periodic audits are a really good idea. People are human. They fall into bad habits. It's a real good idea to check on this about every 6 months and see if everybody is on the same page. And if not, retraining is a real good idea. Failure to sign EHR treatment notes. Rendering healthcare providers often fail to sign or initial each entry. Treating providers should electronically sign and close out each entry on the patient's record that pertains to a treatment he or she rendered. And with EHR, remember, if you're going back and trying to change information, it's going to record that change, who did it, and when they did it. So you can't do this under the table without it being spotted and recognized by the program. And that means it can be discovered by anyone who audits it. Missing medical treatment plans and consent forms, allowing unlicensed staff to provide care. Boy, that's a big one. These are things that you need to watch out for and be sure is not happening in your facility. You want to make sure the consent forms and the treatment plans are always signed. They're signed by everybody. It's in there. It's in the file. I've even seen the physical exams they missing or they weren't done initially. It's just, it boggles the mind sometimes. Next slide, please. Billing for services not rendered. That'll get you caught. Misrepresentation of a non-covered service. Again, you're starting to a form of billing for services not rendered. You're trying to overbill, that sort of thing. Misrepresentation of the provider of the medical service. It's still commonly found in medical practice around the country. In the cases we've seen, fraud wasn't the reason for the underlying misrepresentation on the CMS 1500 claims form. In most instances, it was a matter of a credentialing delay. Depending on the facts, an aggressive prosecutor could argue that such conduct constitutes wire fraud. So again, it just comes down to making sure you're following the procedures and the laws. You have your ducks lined up, and you're not trying to put the cart in front of the horse and do things that are going to create problems for you down the road. Next slide, please. Final considerations. I've got about 3 slides here. So let's talk about more or less a summary of what we've been doing. Physicians must evaluate their financial relationships with potential referral sources. Basically, that's what we talked about before. Look at your relationships and look at your contracts. Find out who you're doing business with, what kind of history they have. Examine your contracts, your leases, your payment arrangements, your compensation. What are you paying for? Are you paying for referrals? Are you creating an anti-kickback problem or a Stark problem or something that won't fit into a safe harbor exception under Stark? Review your ownership structure. Identify any potential anti-kickback or Stark issues. Are you making improper referrals to your own labs because you have an ownership interest and you're not advising the clients of same? Do you have investors who are sources of referrals or who can influence referrals and they're not providing anything other than money and they're getting kickbacks as a result? Review policies, procedures, and training. Oh boy, marketing and community liaison staff. You'll be much better served if your marketing staff are true bona fide employees, and as such, you must train and supervise them to ensure they're acting appropriately. When you hire outside marketers, you lose a matter of control. If you're not doing background checks on these folks and riding herd on them very closely, you don't know what they're doing. And if they're paying patients to come in, you have a world of problems facing you. Next slide, please. Implement and follow an effective compliance program. Boy, this goes without saying. It's been around for so long now, but a compliance program properly utilized is your best tool to avoid problems on the front end before they ever happen. You're required to have them now. It's federal law. It's been out there and it's been enforced at all levels. It's essential that compliance officers working in these areas assess their business relationships as part of an in-depth risk assessment and gap analysis, which you're required to do. Ultimately, you may have only a limited number of choices if management refuses to take remedial action. So what are the implications of the following? You continue to work for the company even though the wrongdoing is taking place. Do you lodge your disagreement with management and continue working? Do you resign? Or do you resign and file a complaint with the affected payors? If you're aware that your organization has engaged in wrongdoing, do you have an affirmative obligation to turn them in? Well, I'm not sure if I could answer that situation because it's all going to be very dependent on the fact situation, what you're in, but I do know this. You would be wise to seek out legal counsel, and my suggestion is going to be you ought to seriously consider getting the hell out of there as soon as you can. Now, after conversation with your attorney, don't know. There might be some key tam considerations you may want to think about, but you're in a bad situation. You need to consider ways to extricate yourself from it. You certainly don't want to be a part of it. Remember that 18 U.S.C. Code Section 4, misprision is a felony. That means knowledge of a felony, an ongoing felony, and you don't tell anyone. That in itself can get you 3 years in prison, assuming the government proves it. And, that means they sweep you up in the net along with it. So be careful. Next slide, please. Retain counsel. Like I say, remember everything you say is evidence. Determine focus of investigation. Is the focus criminal, civil, administrative? Again, counsel can help. Conduct an internal investigation. Get ahead of the government's investigation. Start doing your own. If you think that there's a problem, start doing your internal audit and try to figure out what the heck is going on. Document retention. Don't destroy documents. Don't do it before the retention period is expired and you think there's a problem with it. You might want to hang on to them a little longer. Handling employees. Avoid antagonizing employees. Guard against possible allegations of obstruction. Take the initiative. Aggressively work to resolve the case and work towards a global solution of claims. Don't settle the civil allegations and leave criminal or administrative claims on the table because that can come back to bite you. And that's your leverage. You don't want to just give it away. And I think we may be done. Next slide. I think we're to the questions slide. And we actually did pretty good on the timing. Do we have any questions, Gio?
As for now, we do not. We just have questions about if they're gonna get a copy of the slides. So other than that, I'll just say my ending quote. Thank you guys to our presenters, Robert and Richard, for informative information. And thank you to our attendees for joining us today. I will be sending a copy of the PowerPoint slides tomorrow via email, so look out for that. And if you have any other further questions, please reach out to them. And have a great Tuesday. Thank you so much, Robert, Richard.
Thank you.
Thank you, everyone. Appreciate your time.